And greetings to Habeas Corpus, History and Purposes from American Jurisprudence. Glad you all could make it. Let's get right down to it. Of course, we'll always have Black's Law Dictionary ready at hand to make sure no word is left behind. And we're using 9th edition, so it's very current. And any references before this 9th edition will be made in the American Jurisprudence text. So let's get right down to it. So habeas corpus. So section 1, the purpose of writ of habeas corpus. Before we go into this, I just want to remind everybody that this is just for educational entertainment purposes, that this in no way should be construed as legal, lawful advice in any way, shape, or form for your personal, professional, or other life. Do not use this for any kinds of other purposes other than this broadcast enjoyment right now, and do not try this at home. That being said, let's continue. The writ of habeas corpus traditionally has been accepted as the specific instrument to obtain release from unlawful confinement, or to deliver someone from unlawful custody. Considered the fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action, the writ of habeas corpus is a powerful tool for the protection of individuals' constitutional and statutory rights against overreaching of the government and its agents. The writ serves as a procedural device for subjecting executive, judicial, or private restraints on liberty to judicial scrutiny. And where it is available, it assures, among other things, that a prisoner may require his or her jailer to justify the detention under the law. The writ of habeas corpus gives the judiciary a time-tested device to maintain the delicate balance of governance that is itself the surest safeguard of liberty, and protects the rights of the detained by conferring the duty and authority on the judiciary to call the jailer to account. The essential purpose of a writ of habeas corpus is to subject imprisonment or any other restraint on liberty, for whatever cause, to judicial scrutiny. Habeas corpus is a last judicial inquiry into the validity of a criminal conviction and serves as a bulwark against convictions that violate fundamental fairness. So we're going to get to these footnotes here, but first we're going to read this observation. Before I do that, I just want to make sure if everyone hears my audio clearly and if everything is coming clear on the YouTube end. As far as I can tell, everything is streaming good here. Yeah, I just want to make sure it's all good there. So anything in the comments, I appreciate, just so we know that we're moving along. So this observation here, habeas corpus, rather than mandamus, is the proper action when the petitioner seeks an immediate release from imprisonment. Important note here, the habeas corpus, rather than the writ of mandamus. The purpose of the writ of habeas corpus is not to determine the guilt or innocence of a prisoner. An habeas action does not afford a petitioner the opportunity to retry the case. The great central office of the writ of habeas corpus, the great and central office of the writ of habeas corpus is to test the legality of a prisoner's current detention. The function of a writ of habeas corpus is to inquire into the jurisdictional defects amounting to a want of legal authority for the detention of a person on whose behalf it is asked, and the court in which a writ is sought examines only the power and authority of the court to act, not the correctness of its conclusions. A writ of habeas corpus is available when imprisonment is contrary to federal constitutional or statutory law. That's a good one there, or federal, constitutional, or statutory law. So it's available for any of these times when imprisonment is contrary to federal constitutional law or statutory law. And tests only, here's your test, whether a prisoner has been accorded due process. Let that sink in. It's available when imprisonment is contrary to federal constitutional law or statutory law. And it only tests one thing, whether the prisoner has been accorded due process, not whether he or she is guilty. The purpose of a petition for writ of habeas corpus is not to correct errors of fact, but to determine whether a petitioner's constitutional rights have been violated. Very clear. Habeas corpus is not a static, narrow, formalistic remedy, but one which must retain the ability to cut through the barriers of form and procedural mazes. And the very nature of the writ demands that it be administered with the initiative and flexibility essential to ensure that injustices within its reach are surfaced and corrected. Let me read that again. That's a long sentence. So the habeas corpus is not a static, narrow, formalistic remedy. So we're not looking at a cookie-cutter cookbook approach here, but one which must retain the ability to cut through barriers of form. So it's not a formalistic remedy, but it's one that retains the ability to cut through barriers of form and procedural mazes. And the very nature of the writ demands that it be administered with the initiative and flexibility essential to ensure that the injustices within its reach are surfaced and corrected. That's pretty powerful, I'd say. Let me check on the comments we have here. You have rights, cops have duties. It says, here, let me get over here. So like when I'm going to have to read this because it doesn't fit. Like when I was arrested in the courthouse for trespassing, but never got a prior trespass order in writing, which would be the process of trespassing, correct? So you weren't afforded due process, which would have made a habeas corpus available, apparently. All right. And we got the chosen here too. Welcome. All right. Let's see what else we got here. Yep, let's continue on here. Habeas corpus is, above all, an adaptable remedy, and its precise application and scope change depending upon the circumstances. That's pretty interesting. It's an adaptable remedy, and its precision application and its scope can change depending upon the circumstances. Federal courts and Congress adjust the scope of the writ of habeas corpus in accordance with equitable and prudential considerations. Now, this could be an interesting footnote. Although the writ of habeas corpus is a flexible writ for obtaining a release from custody when one is illegally detained, it has its limitations. So, cumulative supplement here, we have some cases. The core section 2241 habeas corpus action is a prisoner challenging the authority of the entity detaining him to do so, usually on the ground that his predicate sentence or conviction is improper or invalid. From 28, the USCA, that's Ragg versus Ortiz. Okay. Then the sole function of habeas corpus. The sole function is to grant relief from unlawful imprisonment or custody, and it cannot be properly used for any other purpose. So it's not going to help with a judgment of guilt or innocence, but it can be used to grant relief from unlawful imprisonment or custody. So that's the end of the supplement, and let's read these footnotes here. So we'll go by this and we'll refer back up if it seems unclear. So a function of the habeas statute is to provide for a petitioner's release from state custody where custody is premised on an illegal conviction. So this is an interesting one in the 2nd District Circuit, 2008. Then we have the writ of habeas corpus stands as a safeguard of those held in violation of the law. The writ's purpose is to provide a guard against extreme malfunctions in the state criminal justice systems. So that's an interesting one right there. 2018. Oh gosh, what happened here? Uh-oh. Yeah, just a moment here. One more time. All right. Okay, one more time here. Oops. Okay, just a moment here. All right, there we go. Give me a second here. We're going to fix that again now. All right. Pardon that. I guess is a good opportunity to read some comments here. All right. You have rights. You got to get out of here. Yeah, you're welcome. You can always watch this on the on the next on the replay. All right. See what else we got on here. They used to. Okay, yeah, this is true. You have rights. Cops have duties. Says yeah, it tends to happen a lot. They got used to doing unlawful enforcements upon us in the lack of the social media platform and the camera. Always film the police. Yes, I agree with that. All right, let's continue here. So the petition for discretionary review refused and denied. Okay, so this is a case 2017 in Texas. Okay, so the habeas corpus writ provides illegally detained prisoners with a mechanism for challenging the legality of a custodial deprivation of liberty. That's a good term there, a custodial deprivation of liberty. That's probably one to note, and that's from 2008 in Nebraska. And then here are the rest of the cases and the references. And let's see, here's another footnote. While the scope of relief afforded by a writ of habeas corpus has expanded over time, it is not a one-stop shop for a prisoner's grievances. And that's Cummings versus State, 2007. That's New Mexico. All right, let's continue. Section 2, historic forms of writs of habeas corpus. So we have here trial strategy, AmJur. So we could go over this stuff at another time. Habeas corpus is a generic term which was applied under English statutory and common law to several different kinds of writs, a number of which are used in the American legal system. Interesting. So habeas corpus is a term which was applied under English statutory and common law to several different kinds of writs, a number of which are in use in the American legal system. The most important of these is the writ of habeas corpus ad subjiciendum, which is the remedy provided for a person illegally deprived of his or her liberty. That'd be interesting to know how to say. Subjiciendum. Okay, so let's look up this word anyways, because I'd like to see We have footnote 3. Let's see if they give it to us here to save us the trouble. No. Nope. Okay. So it seems to me that this is a good word to know and how to say and where it comes from. So let's figure it out in Black's Law Dictionary. Just a second here. I gotta search it over on this side. Just give me a moment. We'll bring it up over here while we're doing it. And let's look it up. That's a great word. Look up, yeah, let's see it again. Subject, gosh, okay. Let's see what comes up in the search. It's taking a long time to look for it. That's not good. All right, if the search doesn't find it easily, which this is a scanned document and the search doesn't work very well with it. All right, so we have an alternative. What we can do is just search through it here and just hope for the best that I get to it. It's S, so it's somewhere down here. CS. Yeah, the other one's still searching. We'll let that one go. We're just going to keep it moving. All right, P, R. It's sub, so it's going to be way down here, huh? ST, we're getting close. Ah, too far. Let's see, though. Sub should be right here. Almost there. A lot of clicking here. All right, subject. Nope, I just passed it, didn't I? Just saw it. No, I didn't see it. So maybe it's add subject of, oh, geez. Well, we'll look at that one quick, and then we'll get back to the text here. This thing searches awfully slow. I appreciate you guys hanging in there for right now. And we're almost there. Again, it's a lot quicker when you have a text in front of you, which is why I encourage everyone to get a copy of Black's Law. Actually, I could be doing this from a text and just reading it out, but it's this way we have it documented. Oops, wrong. Almost there. So I don't even know if it's going to be in here. I'm hoping it is. The search didn't find it, but I want to make sure because sometimes the search misses it. And if it's in here, we need to know. All right, ads. All right, so I'm not sure if this is all the ads or no. So it's not here. Great. Oh wait, maybe it is ads. So it'll be here already, right? So it's not in here. All right, so great. We wasted that time. But now we know for sure it's not in there. So I got to look in the Latin dictionary for that, which is not going to be now. So we're just going to go along and trust that American jurisprudence is going to give us this in the context. Let's start again here. Apologize for the digression. Let's continue. Habeas corpus is a generic term which was applied under English, statutory, and common law to several different kinds of writs, a number of which are used in the American legal system. The most important of these is the writ of habeas corpus ad subjiciendum, which is the remedy provided for a person illegally deprived of his or her liberty. Where the term habeas corpus is used alone, it is the writ of habeas corpus ad subjiciendum, sometimes known as the Great Writ. That's even easier to say. That is generally meant. This is the sense in which the term was known at early common law, and in which it is used in the Constitution of the United States, all the better. So the Great Writ. I like that, and it's much easier to say. Go check out the real face of your. Okay, yeah, new legal system. Well, we're not buying into that new legal system yet, James Allen Cooper. We're kind of sticking with the American common law approach while we still can, and until they take it away fully, we're just gonna pretend like whatever they're doing in Europe is their thing. We'll see. It's better than giving in too early. All right. So, the Great Writ, that's what we can call it here. And when we say Great Writ, it means this terrible term that we don't want to have to say, because especially if you're being held in prison against your will unlawfully, it's going to be hard to pronounce Latin words. The Great Writ, that is generally meant. This is the sense in which the term was known at early common law, and in which it is used in the Constitution of the United States. So that's good enough for me. The writ of habeas corpus ad respondendum, which was another of the writs which existed under English law, issued where one had a claim against a person who was in custody under process of an inferior court, sought to remove the prisoner and prefer the claim against him or her in a higher court. Jeez. It has been pointed out, however, that although this form of habeas corpus was recognized by English law, it will have no application in a proceeding in an American court, which is a good thing to know. So we have something from Chosen here, and let's read this comment real quick. So a writ for inquiring into the lawfulness of the restraint of a person who is imprisoned or detained in another custody. Yes. Okay. Another of the English writs, the writ of habeas corpus ad satisfacendum, issued where a prisoner had judgment against him or her in an action, and the plaintiff wanted to bring the prisoner up to some superior court to charge him or her with process of execution. However, this writ has also been held not to be available in the United States. Good. The writs of habeas corpus ad prosequendum, testificandum, and deliberandum et recipiendum, also creatures of the English legal system, issued when it was necessary to remove a prisoner in order to prosecute him or her, or in order for the prisoner to bear testimony in any court, or be tried in the proper jurisdiction. Okay, another one that sounds like not to worry of. The writ of habeas corpus cum causa, sometimes called habeas corpus ad faciendum et recipiendum, is another of the forms, and as a rather unusual form of the writ of habeas corpus that existed under English law. It issued where a person was sued in some inferior jurisdiction and wanted to remove the action to a superior court. The writ of habeas corpus cum causa, whose existence has been recognized by at least one early American court, is said to be grantable of common right without any motion in court, and to instantly supersede all proceedings in the court below. That's interesting. So, observation. Here we go. The writ of habeas corpus is an ancient common law right preserved in the federal and state constitutions. Habeas corpus is a common law writ, and the statutes do not define its entire scope. So, are we clear on this? It's an ancient common law right, and it's preserved in our federal and state constitutions. Habeas corpus is a common law writ, and the statutes do not define its entire scope. Entire is keyword. All right, let's read some of these cases here. Implications from statutory text or legislative history are not sufficient to repeal habeas corpus jurisdiction. Department of Homeland Security 2020. Wow. So this would be an interesting thing to look up on and connect. Oh, 2020. Implications from statutory text or legislative history are not sufficient to repeal the habeas jurisdiction. That's good to know. All right, let's see if there's any here that have footnotes along with the cases. As to the constitutional provisions pertaining to the writ of habeas corpus, see Section 3. We're going there next. As to the use of writ of habeas corpus for these purposes, see Section 6. And while the civil practice law and rules govern the procedure of the common law writ of habeas corpus, relief from illegal imprisonment by means of this remedial writ is not the creature of any statute. So civil practice law and rules governs the procedure of the common law writ of habeas corpus, governs the procedure. Relief by means of this remedial writ is not the creature of any statute. So just because it follows their procedure doesn't make it a creature of it. Interesting concept, and that's 2015. All right, now we're on to Section 3. The constitutionality of abrogation or suspension of writ of habeas corpus. So, the Constitution of the United States provides that the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. The suspension clause pertains to the actions of the federal government and not to actions of the states. Thus, the federal Constitution does not require that a state afford a state prisoner unlimited habeas corpus or post-conviction relief proceedings, as only the right to petition the federal courts for habeas corpus and the right of the federal courts to grant a petition for habeas corpus are guaranteed by the Constitution. Nevertheless, similar prohibitions against suspension of the writ of habeas corpus are contained in the constitutions of most states. So prohibitions against suspension are contained in the constitutions of most states. I wonder which ones it's not. That'd be interesting to know. Maybe we'll find out. From footnote 4. I can't wait. Let's find out if it's in footnote 4. We have Kentucky, Nevada, Washington. The writ of habeas corpus derives from common law and is guaranteed by the Nebraska Constitution. All right, well, we know Nebraska supports it. Okay, so there's some good cases there. Let's continue here. All right, so here we go. Absent suspension, the writ of habeas corpus remains available to every individual detained within the United States. While Congress has the authority to suspend the writ of habeas corpus, only in the rarest of circumstances has Congress seen fit to suspend the writ At all other times, it has remained a critical check on the executive, ensuring that it does not detain individuals except in accordance with the law. Moreover, the suspension clause has full effect at the United States Naval Station at Guantanamo Bay, Cuba. And if the privilege of habeas corpus is to be denied to aliens detained as enemy combatants there, Congress must act in accordance with the requirements of the suspension clause. However, the factor of practical obstacles inherent in resolving alien detainees' entitlement to the writ of habeas corpus weighs overwhelmingly against finding that aliens being detained as enemy combatants by the United States government at Bagram Airfield in Afghanistan could evoke the protection of the right of habeas corpus under the suspension clause in a proceeding on a petition for writ of habeas corpus challenging the legality of the alien's detention. As the alien's detention was in an active war zone, the detention was in territory under neither the de facto nor de jure sovereignty of the United States, and the detention was within the sovereign territory of another nation. Aliens who lack constitutional rights of any kind are precluded from invoking the suspension clause. So, it seems like you have to be in some type of American territory to be able to invoke the suspension clause. And again, the suspension clause pertains to actions of the federal government, okay, not to states. A state legislature may regulate the procedure with respect to habeas corpus. So this is interesting to know your state, if they have a procedure, and to some extent, the purposes for which it may be used, to some extent. Thus, it has been held that a state statute prohibiting the filing of successive habeas corpus petitions does not violate the state's constitutional bar to the suspension of the writ. The same conclusion has been reached with respect to a federal statutory provision of this type. So here's an observation. At least one court has pointed out that because of differing functions of state and federal habeas corpus, federal law regarding the suspension clause in the federal Constitution is not determinative of the boundaries of the suspension clause in a state constitution. So this is an interesting observation here, that the differing functions of state and federal habeas corpus, the federal laws regarding the suspension clause, is not determinative of the boundaries of the suspension clause in a state constitution. So I guess the states are independent of that suspension clause, or they have their own. Let's see, and I guess it won't be it's not determinative of their boundaries, is what this observation is relating to, and that's footnote 15. So we'll see if that's some cases related to that later. The substitution by Congress of a collateral remedy, which is neither inadequate nor ineffective to test the legality of a person's detention, does not violate the suspension clause, which generally prohibits suspension of the privilege of the writ of habeas corpus. But the suspension clause is violated where habeas corpus relief is foreclosed and alternative remedies are inadequate to ensure that the petitioner's continued custody does not violate federal law. So that's interesting right here. It's violated, let's see here, that not violate, it does not violate it, right? When is, let's see, neither inadequate nor ineffective, a collateral remedy, right? So we get the double negatives to confuse us a little bit, but this is, they do it for a reason, of a collateral remedy, which is neither inadequate nor ineffective to test the legality of a person's detention, does not violate the suspension clause. So it's going to be adequate and effective, which generally prohibits suspension of the privilege, right? But the suspension clause, so this is something to be aware of. These are precautions because these are the curveballs that people can get thrown when they think they have this all sealed up. That there's no way you can, limit my application of writ of habeas corpus. They could say, no, we have a collateral remedy that's adequate and effective to test the legality of your detention. You don't need to use the writ. You see? So how do we get around this or make sure this isn't used against us? I shouldn't say get around. So let's read into this a little bit deeper, because that's the purpose of American jurisprudence, is to see every angle of this so we form proper strategy should we have to ever challenge unlawful accusations, convictions, and allegations. Okay, the substitution by Congress of a collateral remedy which is neither inadequate nor ineffective to test the legality of a person's detention does not violate the suspension clause, which generally prohibits suspension of the privilege of the writ of habeas corpus. But the suspension clause is violated where habeas corpus relief is foreclosed and alternative remedies are inadequate to ensure the petitioner's continued custody does not violate federal law. To determine whether a jurisdiction stripping statute violates the suspension clause, this is great language, jurisdiction stripping statute violates the suspension clause, which restricts the suspension of the writ of habeas corpus. The court applies a two-step analysis, under which the court first determines whether a habeas petitioner is prohibited from invoking the suspension clause due to some attribute of the petitioner or to the circumstances surrounding his or her detention or removal, and only after confirming that the petitioner is not prohibited from invoking the suspension clause does the court then turn to the second step of the inquiry and consider whether the substitute for habeas corpus provided by the jurisdiction stripping statute is adequate to test the legality of the petitioner's removal. So this is an interesting thing. When there's jurisdiction stripping statutes, this is a great thing to look for. Are they adequate to test legality? And determining whether or not a habeas petitioner can invoke the protection of the suspension clause, which restricts the suspension of the writ of habeas corpus. Do you like how they do this in American jurisprudence? They make sure you're following along because they keep reminding you that the suspension clause is a clause which restricts the suspension of the writ of habeas corpus. So if you haven't got it the first 3 times they've repeated it, it's just, maybe selling tomatoes would be better. They try to make it so that even the most, common layman can understand and practice law and common law, because common law should be for the people. All right. The following factors are considered. 1, the citizenship and status of the detainee and the adequacy of the process through which that status determination was made. So the citizenship status is one of the things, and the citizenship and status of the detainee. 2 things to look at. And the adequacy of the process through which that status determination was made. Interesting. So the check for 1 is not just their status, but also the adequacy of the process through which it was made. So you can't just have some joker public official servant saying, citizenship status is such, or they're a 14th Amendment citizen or an Article 4 citizen, whatever. They're going to have adequacy of process to make that determination. And 2, so the second test, if they pass both elements of that first test, we go to 2. The nature of the sites where apprehension and then detention took place. And 3, the practical obstacles inherent in resolving the prisoner's entitlement to the writ. So there's 3 things we're checking here, right? A federal statute providing that an application for a writ of habeas corpus filed on behalf of a person in custody pursuant to the judgment of a state court may not be granted with respect to any claim that was adjudicated on the merits in state court proceedings unless the adjudication of the claim resulted in a decision that was contrary to or involved in an unreasonable application of clearly established federal law as determined by the United States Supreme Court. That's a mouthful there, but that's pretty important too. We have a federal statute providing an application for a writ of habeas corpus filed on behalf of a person in custody pursuant to the judgment of a state court may not be granted with respect to any claim that was adjudicated on the merits in state court proceedings unless adjudication of the claim resulted in a decision that was contrary to or involved in an unreasonable application of clearly established federal law as determined by the United States Supreme Court. So this can be a very interesting application right here. That may not be granted with respect to any claim that's adjudicated on the merits in state court proceedings unless the adjudication of the claim results in a decision that was contrary to. So if it's contrary to the federal, then you can use the federal to, if it's clearly established federal law, does not violate the federal constitution provision against suspending the availability of the habeas corpus writ, since the statute represents only a modest congressional alteration of standards pursuant to which its writ is issued. The Anti-Terrorism and Effective Death Penalty Act does not deprive habeas petitioners of due process or violate the suspension clause, since petitioners still have every right to bring a claim for habeas relief, and the AEDPA simply requires petitioners to first exhaust state court direct appeal and post-conviction relief remedies before bringing a claim, and requires any claim to be brought within the prescribed time period. See, this is getting a little out of whack here. I can almost guarantee these are recent rulings. Let's look at this real quick, 2021 and 22. See, that's the grounds for granting or denying relief, 1999, 2008, 2009. Yeah. So this is how the common law gets whittled away with these liberal judges. All right. So this is hard to digest, but it's something it's rather important today. So a federal statute, let's follow this here, a federal statute providing that an application for writ of habeas corpus filed on behalf of a person in custody pursuant to the judgment of a state court. So a federal statute providing an application may not be granted to any claim that was adjudicated on the merits in state court proceedings unless it was against clearly established federal law. Okay. This is something that we all need to learn. I mean, you can't. It's like every challenge in life takes a little bit of energy, whether it's physical or mental or emotional. Yeah, there has to be an exertion or a struggle for any kind of progress. So we're doing the mental one right here. And again, hopefully none of this will ever have to happen to any of us. We'll never have to use this. As I always say, preparation is the best form of prevention. So let's continue. All right. So the United States Supreme Court has ruled that the process provided by the Detainee Treatment Act, the DTA, for review of the status of aliens detained as enemy combatants at the United States Naval Station at Guantanamo Bay, Cuba, did provide an adequate substitute for habeas corpus. Sure they did. Given the lack of opportunity for a detainee to present relevant exculpatory evidence not made part of the record in earlier proceedings, and therefore the provision of the Military Commissions Act, the MCA, denying federal courts jurisdiction to hear habeas corpus action by an alien detained and determined to be an enemy combatant or awaiting such a determination was an unconstitutional suspension of the writ of habeas corpus under the suspension clause. Oh, okay. So let's see here. Oh, it did not provide. Okay, cool. I see. So what happened? 24, 25. Let's see. We gotta look up the cases to find out. Boumediene versus Bush, 2008. Nice. Okay. Guess you're going against the executive in that, right? The habeas corpus is the executive branch. Okay, the Real ID Act. Oh, geez. Which provides that the sole and exclusive means for an alien to challenge his or her order of removal based on a claim of United States citizenship is to file a petition for review of a removal order with the Court of Appeals. It is not an unconstitutional suspension of writ of habeas corpus because the new statutory scheme provides an adequate substitute by allowing judicial review of a final order of removal through the courts of appeals. Bullshit. Who did this one? 26? Let's see. Yeah, so 12th. Great. Okay, so anyhow, all's not lost yet. Let's continue on here. Cases. Federal statute limiting habeas corpus review in expedited removal proceedings for aliens who enter the United States illegally and who are deemed to be applying for admission does not violate the suspension clause, which at a minimum protects the writ of habeas corpus as it existed when the Constitution was adopted in 1789, abrogating this versus U.S. Homeland Security, Immigration Nationality Act, whatever. For purposes of the suspension clause, which at a minimum protects the writ of habeas corpus as it existed when the Constitution was adopted in 1789, a writ seeking a new opportunity for an alien to apply to asylum was not a form of relief that was available in habeas. And that was 2020. All right. So let's see here. There is no higher duty than to maintain the writ of habeas corpus unimpaired. 1969. I like this one here. There is no higher duty than to maintain the writ of habeas corpus unimpaired. At the absolute minimum, the suspension clause protects the writ of habeas corpus as it existed in 1789. That's at the absolute minimum. Beautiful. A lower federal court might be the only venue where a prisoner can bring a habeas petition. And in those cases, the suspension clause forbids Congress from withdrawing jurisdiction. The writ of habeas corpus derives from common law and is guaranteed by the Nebraska Constitution. So many states will have similar language like this. You can all look at your own state constitutions to see if the state you're on has a similar language in it, and that would be good to know. Because remember, if it's harmonized that closely with the federal constitution, then you're probably well within the procedure of the standard federal practices of habeas corpus with your state. But otherwise, there might be other procedural elements that your state would have that it would just behoove you to be aware of. Despite the fact that all claims that can be channeled into a state's Post-Conviction Relief Act should be so channeled, the privilege of the writ of habeas corpus has not been suspended. Challenge with states see, this is strange. Post-Conviction Relief Act. That sounds a little too late for habeas corpus to me. That's the writ of mandamus for that, right? Restrictions on second or successive habeas petitions do not constitute suspension of the writ of habeas corpus. So restrictions on second or successive. Make sure you get it right the first time. 2017. Yeah, that's sounds about right. Jeez. Yeah, again, like the regular people when they do this every day. So, of course, they have to do a second or successive one because they didn't get the first one just perfect. You wouldn't want to worry about that. Okay. As to the federal prohibition against successive habeas corpus petitions, see Section 109, as a grounds for granting relief or denying relief. Okay. Most cases in which an alien is removed while his motion to reopen remains unsolved, the INA's jurisdiction stripping provisions is that jurisdiction stripping provisions do not violate the suspension clause because the existing administrative scheme is an adequate substitute for habeas corpus relief. And if you want to see how they came up with that, you can read this case. 2019, holding. However, that an emergency motion to stay was an inadequate substitute for habeas corpus relief for an alien, and thus the suspension clause prevented the INA's jurisdiction stripping provisions from being used to deny the court jurisdiction to hear his claim. Jurisdiction stripping provision. Okay, now we're on to a frightening one here. The constitutionality or abrogation or suspension of writ of habeas corpus under martial law. Okay, just check and see if everyone's still here. Looks like we still have some people in the chat. That's good. Let's continue here. Now, I do have some forms and practice forms with American Jurisprudence. They're not in the digital form like this, but I might just have to go through some of those and see if we can go through some examples and forms, and maybe I could just bring those up on a monitor, a video monitor, so we could look at those on a future stream. But if I can find digital ones, I'll find those because they're much easier, I think, to share. All right, let's continue here. Although the U.S. Constitution expressly prohibits the suspension of the writ of habeas corpus, that prohibition is subject to the express exception embodied in the words, unless when in cases of rebellion or invasion, the public safety may require it. There is some early judicial authority for the proposition that it is competent for the executive or military officer in command either to suspend the writ of habeas corpus or to disregard it if issued, whether the exigencies of the case demand such an action for the purpose of putting down an insurrection, or rebellion. Oh, gosh, and this is from 1899 and 1900. Furthermore, it has been said that from a practical standpoint, the suspension of the writ is a concomitant of a declaration of martial law. However, it has been held that the power to suspend the writ, if such power exists, is exclusively a legislative function, which may not be exercised by the executive, and that the proclamation by the executive of the existence of an insurrection and his or her calling out of the military force to suppress it do not abridge the right to use the writ of habeas corpus for the purpose for which it was intended. Thus, it has been held that in the absence of a congressional action, a writ of habeas corpus cannot be denied in a proper case, even in wartime. Now, that's a good one there. Let's see, it's number 6. All right, let's read this one first. It was because of doubt as to where the power lies that Congress, in 1863, provided by an enactment that the President was authorized to suspend the privilege of the writ of habeas corpus, whether, in his or her judgment, the public safety required it. Congress has the authority to suspend the writ of habeas corpus, and that's 2018. if at any time the public safety should require the suspension of the powers vested by the statute in the courts of the United States to issue writs of habeas corpus, it is for the legislature to say so, as the question depends on political considerations on which the legislature is to decide. 1807. Interesting stuff here. And we're on to 5, the function and scope of the remedy of writ of habeas corpus. All right, if you guys are enjoying this, please hit the like, and that way we can keep making sure that more of this American jurisprudence gets out there and people show up, because I have been shadow banned lately. Sometimes nobody gets notifications, not even me. So I'm glad everyone's here tonight. Let's continue. Habeas corpus furnishes an extraordinary, limited remedy against a presumptively fair and valid final judgment. That's interesting there. An extraordinary, limited remedy against a presumptively fair and valid final judgment. The essence of habeas corpus is an attack by a person in custody upon the legality of that custody, with the traditional function of the writ to secure release from illegal custody. The writ of habeas corpus is an extraordinary writ and will only be issued in certain circumstances of unlawful restraint of a person's liberty where there is no adequate legal remedy of law. A habeas corpus petition is a collateral attack on a judgment, the purpose of which is to ascertain whether the petitioner has been confined unlawfully. It is a collateral attack that is separate and distinct from direct review, and occurs only after a prisoner has failed to obtain relief by direct appeal. Because a petition for writ of habeas corpus collaterally attacks the final judgment, review is limited. This limited nature of the writ of habeas corpus is appropriate, because use of the writ tends to undermine society's legitimate interest in the finality of its criminal judgments. The central characteristic of the writ of habeas corpus is the speed with which it triggers judicial scrutiny, and in fact, habeas corpus is considered a summary remedy. Moreover, the writ of habeas corpus does not act upon the prisoner who seeks relief, but upon the person who holds the prisoner in what is alleged to be unlawful custody. A writ of habeas corpus is an order from a judge commanding a party who is alleged to be restraining the applicant in some way to appear before the court with object of alleged restraint and explain the reasons for restraint. A writ of habeas corpus essentially initiates the process by which all persons involved are noticed that the court is considering the issue of an individual's restraint. Parties are physically attached, if necessary, and the response or return is made. Practice tip. The federal statute authorizing the issuance of writs of habeas corpus implements the general grant of habeas authority provided by the Constitution. It has been pointed out that habeas corpus lies to enforce a right of personal liberty, in that when the right is denied and a person is confined, the court can only act on the body of the individual by releasing him or her. It cannot revise a state court judgment, construing every federal grant of habeas corpus to a state prisoner as carrying an attendant list of unstated acts or omissions that the state must perform or not perform, would substantially transform conditional habeas corpus relief from an opportunity to replace an invalid judgment with a valid one, to a general grant of supervisory authority over state trial courts. Thus, the only remedy which can be granted on a petition for writ of habeas corpus is release from custody, whether absolute or conditional. While a habeas petition is a vehicle capable of challenging the basis of a governmental restriction on a person's liberty, It is not capable of addressing private property rights. Consequently, habeas corpus is not available to recover a fine, to recover money damages, or to obtain injunctive relief. Okay, so we know that habeas corpus has a very narrow scope here. Cases. Habeas is at the core remedy for unlawful execution. Habeas corpus is at its core a remedy for unlawful executive detention, and that was 2020 against Homeland Security. The purpose of a writ of habeas corpus is to test the validity of a detention, and for this purpose, the law permits a prisoner to mount a collateral attack upon his conviction or sentence. A habeas corpus petition is a collateral attack on a presumptively valid judgment. Thus, the petitioner bears a heavy burden initially to plead sufficient grounds for relief, and then later to prove them. Habeas corpus can only be used to review 1. Whether the court had jurisdiction of the crime and the person of the defendant, 2. Whether the sentence was authorized by law, and 3. In certain cases, whether an incarcerated defendant has been deprived of basic constitutional rights. That was 2016. The writ of habeas corpus must be administered with initiative and flexibility essential to ensure that miscarriages of justice within its reach are surfaced and corrected. So it must be administered with initiative and flexibility, essential to ensure that miscarriages of justice within its reach are surfaced and corrected. 2 things, 1969. And we have petition for discretionary review refused and denied. Habeas, by its very nature, is an action to challenge the fact or length of custody for which the remedy is released from custody. It is not an action in damages. Habeas corpus is not an appropriate or available remedy for damages claims, which can instead be pursued by a prisoner by means of a civil action. All right. So let's see where we are here. We're at the 1 hour mark. Do we still have people here, or are we losing everybody? Let's see else. Just checking the chat here. Because we're on to obtaining production of prisoners as witness for trial through writ of habeas corpus. All right. So, the writ of habeas corpus ad testificandum, which was used under English common law to secure the presence of a prisoner as a witness in a judicial proceeding, is in use in this country. Although in some jurisdictions a common law writ of habeas corpus ad testificandum has largely been superseded by statute. Likewise, the writ of habeas corpus ad prosequendum, the common law form of the writ of habeas corpus that was used to obtain the presence of a prisoner for prosecution, remains a viable remedy under American law. Although not using the terms writ of habeas corpus ad prosequendum and writ of habeas corpus ad testificandum, a federal statute authorizing the issuance of a writ of habeas corpus by various federal courts provides that the writ shall not extend to a prisoner except under certain circumstances, including those situations in which it is necessary to bring the prisoner to court to testify for a trial. It is recognized that this provision authorizes a court to issue both the writ of habeas corpus ad prosequendum and the writ of habeas corpus ad testificandum. The federal court is permitted to issue a writ of habeas corpus ad testificandum when necessary to direct the custodian of the federal prisoner to produce the prisoner for appearance in court. Geez, that's practice tip. A writ of habeas corpus ad testificandum differs from a witness subpoena. Oh, okay. In that a witness subpoena orders the individual whose testimony is sought to attend the trial, while a writ of habeas corpus ad testificandum is directed to the custodian of the potential witness. I get it. So subpoenas to the witness directly, habeas corpus ad testificandum is to the custodian or the whoever's watching over that prisoner. Okay. The federal statute authorizing the issuance of writs of habeas corpus states that such writs may be granted by the Supreme Court, any justice thereof, the district courts, and any circuit judge within their respective jurisdictions. Notwithstanding the foregoing territorial limitation, the statute is deemed to impose no territorial limitations on the power of the U.S. district courts to grant a writ of habeas corpus ad prosequendum. The courts have also taken position that there is no such limitation upon the jurisdiction of federal courts to grant a writ of habeas corpus ad testificandum. District courts have authority to issue writ of habeas corpus ad testificandum to require production of a person incarcerated outside the district to testify. It has been held that a federal court's authority to issue a writ of habeas corpus ad testificandum to secure the testimony of a prisoner extends to those persons in custody under a sentence of a state court. A writ of habeas corpus ad testificandum can be used to get a prisoner into the district court from anywhere in the country and from a state facility as well as a federal one. Wow. So caution, although not addressing the territorial jurisdiction of district courts with respect to the issuance of writs of habeas corpus ad testificandum, the U.S. Supreme Court has stated that its determination with respect to the territorial jurisdiction of the federal district courts in cases involving the writ of habeas corpus ad prosequendum does not support an expansive reading of the power conferred upon federal district courts by the writ of habeas corpus ad testificandum. Okay, so I'm going to skip over some of this here because we're getting a little into the weeds here. So civil or criminal nature of habeas corpus proceedings. So this is going to be a good one here. Habeas corpus proceedings are generally considered to be civil rather than criminal in nature, even when the writ is sought on behalf of one charged with or convicted of a crime. Now that's interesting. Still considered civil in nature. While habeas petitions are filed by persons previously convicted of criminal offenses to challenge those convictions or the effects of those convictions, habeas corpus proceedings are civil in nature, not criminal. A habeas corpus action, as a variant of civil actions, is subject to the ordinary rules of civil procedure, unless superseded by the more specific rules pertaining to habeas actions. Habeas corpus is an original civil remedy for the enforcement of the right to personal liberty, rather than a stage of the state criminal proceedings or as an appeal therefrom. However, although habeas corpus proceedings are characterized as civil, the label is gross and inexact, and essentially, the proceeding is unique. So as to the civil or criminal nature of the proceedings under statutory substitutes for habeas corpus, see Section 9. And habeas corpus is not a criminal proceeding, but is considered to be civil in nature, and it is a collateral attack that is separate and distinct from direct review, and occurs only after a prisoner has failed to obtain relief by direct appeals. And as to the procedure, see Section 93. Now we have the equitable nature of habeas corpus relief. This should be interesting. A number of courts have expressed the view that habeas corpus is a remedy which is governed by equitable principles. Thus, based upon this view, a petitioner may, by his or her own conduct, such as bad faith, be barred from obtaining the relief sought. Wow, coming in bad faith, not coming in equity. However, the mere fact that the writ of habeas corpus has been called an equitable remedy does not authorize a court to ignore the body of statutes, rules, and precedents guiding its usage. 4. Let's see that real quick here. Yeah, 1996. Okay. Observation: while most courts state that habeas corpus is, at its core, an equitable remedy, several courts state that while equitable principles govern a habeas corpus proceeding, it is a legal, not an equitable remedy. Jeez. What states are those? 5. 2013, 2015, 2018, 2017. Yeah, so this is a growing trend that's disturbing. Equitable principles govern it. It is a legal, not an equitable remedy. So, relief under post-conviction relief statutes comparison to habeas corpus. So this is an interesting distinction here. Some jurisdictions afford prisoners who have been confined pursuant to the sentence of a trial the right to seek relief from that confinement on specific grounds by means of a motion filed in the trial court attacking the validity of the sentence. For example, a federal statute provides, among other things, that a prisoner in custody under a sentence of a federal court claiming the right to be released upon the ground that the sentence was imposed in violation of the Constitution or the laws of the United States, or that the court was without jurisdiction to impose such a sentence, or that the sentence was in excess of the maximum authorized by law, or is otherwise subject to collateral attack, may move the court which imposed the sentence to vacate, set aside, or correct the sentence. The statute further provides that an application for a writ of habeas corpus in behalf of a prisoner who is authorized to apply for relief by motion pursuant to the statute may not be entertained if it appears that the applicant has failed to apply for relief by motion to the court that sentenced him or her, or that such court has denied the applicant relief, unless it also appears that the remedy by motion is inadequate or ineffective to test the legality of his or her detention. Similarly, the Uniform Post-Conviction Procedure Act provides that a person who has been convicted of and sentenced for a crime may apply for relief under the Act upon various grounds, including the ground that the conviction was obtained where the sentence was imposed in violation of the Constitution of the United States or state constitution, or, that's nice, and that the conviction was obtained under an unconstitutional statute or for conduct that it was constitutionally protected, and that the court that convicted and sentenced the applicant was without jurisdiction over the person of the applicant or the subject matter, and that the sentence was not authorized by law, that evidence not previously presented and heard existed requiring vacation of the conviction or sentence in the interest of justice, that a significant change in substantive or procedural law had occurred which, in the interest of justice, should be applied retrospectively, that the sentence had expired, probation or parole or conditional relief was unlawfully revoked, or the applicant was otherwise unlawfully in custody or restrained, or that the conviction or sentence was otherwise subject to collateral attack upon any ground of alleged error previously available under any common law, statutory, or other writ, motion, proceeding, or remedy. Some long sentence. Okay. A defendant does not have a constitutional right to post-conviction review. A right to file a post-conviction petition is a statutory right, and a post-conviction petitioner therefore receives no more rights than those granted by statute. Okay, so I like the observation. Much easier to digest. Proceedings under Provision Relief Acts have also been deemed to be similar to those in habeas corpus, and to be generally available on the same grounds as, and as a replacement for, or implementation of habeas corpus. As is the case with habeas corpus proceedings, the purpose of post-conviction proceedings is not to determine guilt or innocence, but to inquire into the constitutional issues which have not been and could not have been previously adjudicated. Post-conviction procedures do not provide petitioners with a super appeal. Rather, they provide a narrow remedy to raise issues that were not known at the time of the original trial or were unavailable on direct appeal. That is an interesting one here, too. A petition for writ of habeas corpus may not be used as a substitute for an appropriate post-conviction motion, nor is it an opportunity to raise the issue again if it has already been considered in a post-conviction proceeding. The purpose of such statutes generally is not to confer a broader right of attack on a judgment and sentence than might theretofore have been made by habeas corpus, but rather to require that the attack, which might have been made in some other court through resort to habeas corpus, may be made by motion in the sentencing court unless it appears that the remedy by motion is inadequate or ineffective to test the legality of the prisoner's detention. So we hear that same theme again about the inadequacy or ineffectiveness of a test of legality. So that would make it unconstitutional. Okay, so like habeas corpus proceedings under the post-conviction release statutes are generally deemed to constitute an independent and collateral attack on judgment. Such proceedings are a means of testing the validity of the person's detention after conviction. So the release statutes are deemed to constitute an independent and collateral attack on judgment, and the proceedings are a means of testing the validity. So there it is. However, the remedy afforded by the writ of habeas corpus post-conviction relief proceedings are not a substitute for an appeal, nor used to litigate questions that were raised and decided on direct appeal. Like habeas corpus proceedings on applications for post-conviction relief are generally deemed to be separate from the underlying criminal action, civil in nature, and governed by the rules applicable to civil proceedings. Moreover, such proceedings are generally deemed to be actions at law. Nice. It has been widely recognized that the Post-Conviction Relief Action Acts, although requiring a convicted individual who seeks to collaterally attack his or her sentence or on constitutional or certain other enumerated grounds, to do so by means of a motion filed in the trial court in lieu of an application for writ of habeas corpus, do not violate constitutional prohibitions against the suspension or abrogation of the writ of habeas corpus, at least where they provide a reasonable substitute for the writ. Reasonable substitute. Yeah. Rather, and that's 27. Let's see, where is that? Reasonable substitute. We can read more about that on this here in 27. That's Com versus Markham, Kentucky, 1994, and Bartz versus State in Oregon, 1992. Okay. Rather, they prescribe the procedure to be followed in seeking enforcement of those rights and include all relief available by habeas corpus when used for the purpose of seeking to vacate, set aside, or correct a sentence. Provisions establishing statutes of limitations with respect to the filing of applications for post-conviction relief has also been held not to violate constitutional prohibitions against suspension of the writ of habeas corpus. So here's our cumulative supplement here. Cases. Concerns with parallel litigation and conflicting judgments are why Congress has determined that a petition for writ of habeas corpus, not a Section 1983 action, is the appropriate remedy for state prisoners attacking the validity of the fact or length of their confinement, including confinement pending trial before any conviction has occurred. So there you go. As from concerns with parallel litigation and conflicting judgment, why Congress determined that a petition for writ of habeas corpus, not a Section 1983 action, is the appropriate remedy for state prisoners attacking the validity of the fact or length of their confinement, including confinement pending trial before any conviction has occurred. So this is great. 42 U.S.C.A. 1983, McDonough, whatever, versus Smith. Connecticut, 19. Defendant's motion to reduce his sentence under First Step Act was not an attack on his sentence, nor an argument that he was entitled to a new one, and thus did not conflict with his agreement, with the government waiving his right to file future post-conviction motions related to the substance of his case or sentence. First Step Act gave defendant the right to petition for a reduced sentence under the court's newly afforded discretion that did not exist when the defendant waived his right to file motions. Oh, gosh. Post-conviction proceedings are not a super appeal. Rather, grounds enumerated in post-conviction rules are limited to issues that were not known at the time of the original trial or that were not available on direct appeal. This post-conviction rule. Standing to file a motion to vacate sentence does not hinge on the requirement of being any prisoner in custody under sentence of a court of record of the state, but instead, post-conviction relief is available to any person sentenced by a court of record of the state. Standing to, okay, and a supplement there. And we go to generally claims asserted by federal prisoners that seek to challenge their convictions or the imposition of their sentences must be filed as a motion to vacate sentence in the jurisdiction of the sentencing court, while habeas corpus claims seeking to challenge the execution or manner in which the sentence is served must be filed in the court having jurisdiction over the prisoner's custodian. The rule governing motion to vacate a sentence contains narrowly circumscribed safety valve that permits a federal prisoner to petition for a writ of habeas corpus if it appears that the remedy by motion is inadequate or ineffective. Okay, a petitioner seeking to challenge conviction has a burden of showing that the remedy under the statute governing motions to vacate would be inadequate or ineffective. So you get the burden. A motion to vacate, set aside, or correct sentence is the primary means in which a federal prisoner may collaterally attack the legality of his conviction or sentence. So a motion to vacate, that's the primary means. However, the habeas statute may be utilized by a federal prisoner to challenge the legality of his or her conviction or sentence if he or she can satisfy the mandates of the so-called savings clause. 2010. A motion to vacate is ordinarily the only means to challenge the validity of a federal conviction following the conclusion of a direct appeal, but in rare instances, a prisoner may attack his underlying conviction by bringing a habeas corpus action under the savings clause of the statute governing motions to vacate. Wow. That'd be interesting to read up on. As a general rule, the motion to vacate sentence provides the correct avenue to challenge a federal conviction or sentence, whereas a federal prisoner may file a habeas corpus petition if he is challenging the execution of his sentence. An example, the Bureau of Prisoners, calculation of sentence credits, or other issues affecting the length of his sentence. So as a post-conviction relief statutes precluding habeas corpus relief, Uniform Post-Conviction Procedure Act. The Uniform Post-Conviction Procedure Act, the UPCPA, is an expansion of the writ of habeas corpus. The UPCPA comprehends and replaces all other common law, statutory, or other remedies, including the writ of habeas corpus, that were previously available to collaterally challenge the validity of the conviction or sentence, and that's 2012. The Uniform Post-Conviction Procedure Act. Expansion. Nice euphemism. Okay. Individuals convicted of state crimes have no federal constitutional right to a state post-conviction proceeding, and as a result, several states have substantial discretion to determine what post-conviction procedures, if any, each will provide. Motion to vacate or set aside a correct a sentence is a substitute for habeas corpus, and thus relief is available only if the same relief is available under the writ. Although motion to vacate is not technically a writ of habeas corpus, but rather a motion to set aside, vacate, or correct a sentence, it may afford the same relief, and it is a practical substitute for habeas relief for federal prisoners. Motion to vacate. Motion to vacate, set aside, or correct a sentence is intended to afford federal prisoners a remedy identical in scope to federal habeas corpus. And the Nebraska Post-Conviction Act is the primary procedure for bringing collateral attacks on final judgments in criminal cases based upon constitutional principles, And if a defendant has a collateral attack that could be asserted under the Act, that Act is his or her sole remedy. So lots of case laws here. I'm not going to read them all because they keep reasserting what we already read. Last one here. The statutory remedy of the post-conviction relief is available to any person who has been convicted of a crime and who thereafter alleges either that the conviction violated the applicant's constitutional rights or that the existence of the newly discovered material facts requires vacation of the conviction in the interests of justice. So you're a statute creating a special appellate and post-conviction procedure for capital cases, which establishes statute limitations for post-conviction petitions, was not an unconstitutional restriction on the right of habeas corpus of a petitioner for post-conviction relief. The legislature could pass statutes regulating the use of the habeas corpus, and the Post-Conviction Procedure Acts have replaced the habeas corpus for the purpose of challenging the validity of the conviction. Jeez. So now they get statutes of limitations in there, right? All right, so we could leave off here and start next time with Section 10 for federal court, the right of state prisoner to writ of habeas corpus in federal court. So, on that one there, I want to thank everyone for coming in tonight. This has been a great learning process for me, and I hope everyone else here. The power of the habeas corpus, where it applies, how we should know the difference of when to use it, and the post-conviction procedures, how state statutes can affect the procedural effects, not the scope of the habeas corpus in most cases, and that when there's other remedies available, it could interfere with us using the habeas corpus. So having all these precautions in mind, understanding the successes that have been used in them in various situations allows us to have a wide understanding of when this very important and powerful instrument may be used to protect our rights. And again, as we see the history of this from common law in England all the way to here in America, that this is one of the precious things that have been part of our law legacy and has really set us apart from much of the world. And one of the key things I've taken from this is the due process part here too, is that habeas corpus can be an effective attack on due process when it affects us in an immediate manner, such as an unlawful detainment. So those things alone, those elements alone of the habeas corpus mean that everybody should be familiar with this instrument. It's integral to our freedom here in America. And I want to thank everyone for being here and spending your time here with all the other interesting and exciting things that are on the YouTube metaverse, that you found the time to be here and learn about the habeas corpus along with me. And I hope that you'll be here for the next journey as we continue with American jurisprudence and common law. So I want to thank you all for coming, and I hope to see you all on the next one. Peace out.